stark as the solecisms.
Do I understand you, General, going back to Justice Gorsuch's first question, to continue to maintain that, in fact, there is no requirement for notice and opportunity for a hearing? Is that right?
Absolutely, yes.
And why is that? Just because it's not stated in the statute?
It's not stated explicitly in the statute, and Congress knows how to provide that because it did so a month earlier in a similar statute and has done so in many, many statutes.
It doesn't do that. Yeah, I thought that with respect to the neglect and efficiency standard, you do recognize notice and a hearing for that, but not in this statute. Why the difference? Because neither is stated.
Yeah, two reasons. In both Shurtleff and Reagan, this court expressly recognized that that phrase INM or specified causes would bring with it notice and a hearing. And that's part of the court's holding in Shurtleff, as I read it, because there it was an INM standard,
right.
And there's a removal with no notice or hearing, and the court held, well, clearly this wasn't for INM because it was notice and hearing.
Your reasoning would be that that was a mistaken holding, because since it's not stated in the statute, there's no need for notice and hearing.
Not exactly, because the old soil argument that we reject as to just simply cause is, we admit, much stronger when it comes to specified causes. So we don't think the court necessarily got it wrong in Reagan when it said specified causes mean that notice and a hearing are provided, because the case law, it's the one point in which the sort of background case law does seem to be unanimous. On the other issues where they contended the case law all goes in one direction, you have their own sources saying they're all over the map, they're directly contradictory.
But the outcome of your position is that in this case, where you don't have the inefficiency neglect standard, the president need not provide any notice, the president need not provide any hearing, the president just really has to say, Ms. Cook, you're fired.
He has to provide a cause. We contend that there has to be a cause, something that relates to conduct, fitness, sufficiency, or competence. We concede it cannot be for policy disagreement or for no reason at all or at will.